Hello friends, I hope you're doing awesome. And today in this video, I'm going to talk about everything that you need to protect your company that is into EV. I will give you all the facets of intellectual property that you can utilize to protect various aspects of your company under various aspects of intellectual property. So I will be briefing you how to choose a name and then protect it under trademark. Then copyrights, how to protect your copyrights. Then design registration or design patent, you may call it. Okay. And last, the patents. I will be giving you an entire strategy of how you can invent, protect and enforce your patents as well. And also I will be giving you a history of EV. When was EV invented first and till date what is happening with it. And also watch this video till the end. I will be giving you a link that will help you in downloading a document which will tell you everything about EV, including government schemes. So stay tuned. So first I will start with the history of EV. What do you think when the electric vehicle was invented first? Okay, the invention of electrical vehicle started with the invention of electric motors, the prime mover. Okay, with that invention, the concept of EV was put forth by Alois Jadlik in 1928. He invented electromagnetic rotating device, and he also prepared a conceptual prototype where he showed how an electric vehicle can run. Did he create a running model? The answer is no. He just created a prototype and the concept. The first electric vehicle that was running on road was developed by Mr. Thomas Parker in 1884. He was the first person to develop a full-fledged electric vehicle which he used to commute from his office to home, and it was running on road. This was the first successful EV that was running on road. And thereafter many companies started manufacturing and selling EV. If you know, recently Porsche launched its full-fledged EV which could run at least 400 to 500 kilometers in a single charge at a very high speed. It's a sports vehicle. Okay, but the history of Porsche is the first vehicle that Porsche made was electric vehicle. Did you know this? No. In 1898, the first EV was launched commercially by Porsche. Okay, and from that date onwards, in earlier 90s, there was a massive rise in the utility of EV. 40% of the market share was captured by electric vehicles. There were steam driven vehicles, there were internal combustion vehicles, but the advantage with the EV was it was easy to start, easy to operate. There were no gears, the rigid gears, shifting of gears required. There was no cranking required to start a vehicle. But EV had many advantages. That is the reason it became popular during earlier 90s. But later on, due to industrial revolution and many other reasons, it saw a downfall. Okay, and during this downfall, internal combustion engine got its popularity. Okay, the internal combustion engine driven vehicles were utilized extensively. Lot of modifications were made in that, and even today I prefer to use internal combustion engine because though EV seems to be a green option, but it's not that green. So I'm just waiting for the next revolution to happen in this industry. It will be more eco-friendly. Why people are now moving towards EV? The answer is every country does not have abundance of crude oil. Okay, they are dependent upon major countries which have natural resources of this crude oil. That is the reason these countries have a monopoly and they can change the price. That is how they are playing with the economy. To break this monopoly again, government started promoting EVs. And this was the brief history of electric vehicles. If you want to start a company, or if you already have a company which is selling EV or components of EV, I will brief you all the facets of intellectual property rights, and then I will tell you how to utilize it effectively. First thing that any company needs is a name. correct? A name that can be protected under trademark. Okay, a trademark is a sign that distinguishes the goods or services of a given enterprise and distinguishes them from its competitors. Okay, the Trademark Act 1999 defines trademark as a mark capable of being represented graphically, which is capable of distinguishing the goods or services of one person from other, and may include shape of goods, their packaging and color. Okay, section 2M of the Trademark Act also defines mark as includes a device, a brand, headline, label, ticket, name, signature, word, letter, number, shape of goods, packaging and combination of colors and any combination thereof. So all these things can be protected under trademark. Okay, how to coin a beautiful word for your company? Okay, people tend to choose a generic word which correlates to their product. Okay, by choosing this name, your effectivity of trademark reduces actually. Okay, urja for example, or power if I use, or electric powered vehicle if I use it, okay, then it becomes little difficult to enforce these kind of names. So the first thing that you need to do is coin a beautiful word. I have one good example. Ola, they are into electric vehicle, they already have a brand. One of the unique name that I saw in EV industry is ether. It's a coin word, I don't know what it means, but many people will not opt to use it, and if someone opts to use something similar, they will be able to enforce it very effectively. Author does not relate to electric vehicles. It does not have anything that is meant to be electrical, at least in English and our regional language, Hindi, we don't have any correlation with it. So similarly, if you are able to coin a beautiful word, a unique word for your company, then it's the best. For getting a protection for the word is your priority. If you get protection for the word, you can change your logos multiple times, right? Like Twitter did. They changed their logo several times. Now it is taken over by X. Similarly, Google, they are changing their logos multiple times, but name has not changed. Okay. So first priority would be to coin a unique word. Second step would be to do a trademark search, a thorough search. Okay. Get a thorough search from consultants who are expert in this industry. Don't just call anyone and ask, ये available है क्या, कर दो 1000 रुपए में. Okay, this is a very wrong strategy because the name of the company goes perpetual from one generation to another generation. It may create a problem in future. Getting a trademark registration is one thing, and not infringing someone else's trademark is another thing. Okay, the first thing that you should do is get a trademark search done and get an opinion whether that you can get a trademark application registered, first thing, or is there any possibility of infringement. Okay, you can do it in all the jurisdiction in which you want to launch the product. For example, if you want to launch the product only in India, then do a trademark registration, trademark search in India itself. That's it, that is enough. But if you have an aspiration to expand your business across the geographies, different countries, then it is preferred to take an opinion on availability of this mark in those jurisdictions as well. Just for your example, I have a company in India and I also want to launch the same company in China, Europe and Middle East, just for an example. If at all it's not possible to use the same name in other country, then it will become a problem. Correct? If the name is not available, you have to rebrand your product. And again, doing that publicity to attract customers will be costly. So initially, whatever you are going to invest in trademark will definitely turn fruitful if you have a vision, a bigger vision. If you don't have that vision, and then you can go with the other resources that I have mentioned earlier. Okay, so the first thing is name, coin a name, get a trademark search, whether it can be registered or it has any infringement possibilities. Okay, next thing is if you have the name, register it, file a trademark application for it, and then go for company registration. If at all there is a possibility that you are not able to get the word, there is some conflict, then you combine one or two words together, okay, and then you combine it with a logo. So words plus logo becomes a device mark. So in worst cases, you can go for device mark, okay, it's not preferred. But if at all you don't have any option, you want to use generic terms to attract more customers, in that case you can use generic words. But just remember, when you're using generic words, other people also can use that generic words, change the logo, okay, and then still manufacture and sell the product under the same brand. So it will be difficult to distinguish two products. Okay, just for example, in India, Kolhapur misal, the word is very famous, right? Everyone relates to Kolhapur misal. So everywhere there are Kolhapur misal outlets. So it will be difficult to find which Kolhapur misal I liked. There are small here and there differences, but it is difficult to remember that this is different, that was different. This is the second case. Word plus logo you can protect under device mark. Or if you want, you can protect your name separately and logo separately. This is the beautiful combination any company can have. That's the best thing that you can do with the trademark. Okay, so name separately, logo separately, or combine it together if you don't have a choice. Okay, these are the few logos. From the logo itself you can recognize which company it is, right? So it becomes very identical to recognize a company based on logo as well. So logo is also important for every company. So next is color combination. If you have a unique color combination for your vehicle, definitely you should also protect that color combination, because if you see a Ferrari, it has a unique red color. If you see a John Deere tractors, it has a unique green and yellow color. So these colors are also protected under trademark. If you want to represent your product very uniquely, or you are creating some unique colors for your vehicles, those also can be protected. So next thing that you can protect under trademark is sound. For example, a firing of the vehicle. It may not be relevant for EV, but for internal combustion engines, you see there is a different firing for Bullet, there is a different firing for Honda, there is a different firing for Harley Davidson. So if that is relevant for you, you can choose for it. Or nowadays people are also protecting the sound of their horns. Okay, the way horns are sounding. So if that is possible, you can create a unique horn for your vehicle, and that also can be protected under trademark. So if you see, there were unique sounds that you can correlate with a product. So Nokia, there was a unique sound, right? So Titan, there was a unique music that when someone plays, you will definitely correlate to it. So that way you can also create a unique sound for your brand, where if the sound buzzes, people will know that your vehicle is running, or it's your vehicle related ad. Okay, so this is another thing that you can do with respect to trademark. Next category is well-known categories. Basically, trademark has 45 classifications based on goods and services. When you apply for a trademark, so you will have to apply under class 12. Okay, so I will give you the classes under which you need to apply for the trademark. So here are the classes. So whenever you apply for a trademark, basically if you're launching an electric vehicle, then it will be class 12. If you have any accessories, any components that are required for EV, it will be class 9. And if you are giving charging services, if it is related to any kind of a charging service, charging station related services, then it will be class 37. Okay, so basically 45 different classifications. You cannot have protection under all 45 classifications. To get protection under all 45 classification, your mark has to be well-known mark. So is it required? The answer is no. But will it be good? Yes, the answer is yes, because there will be no other brand with the same name. That will be highly recommended. So to get all protection in all 45 classification, your trademark has to be well-known. Okay. Earlier, the trademark were recognized as well-known marks, but nowadays you can apply for a well-known mark by paying 1 lakh rupees fees to the government, and whatever consultant charges you for this registration, you can get a well-known mark, provided it is extensively advertised across the geography. Okay, there are a lot of promotional activities happening with this particular mark. At least it is registered in 1 or 2 classifications, and there is a history of enforcement. Means you have taken legal action against the people who are using similar word. If these are fulfilled, then probably you can get a well-known mark, which means in all 445 categories, no one would be able to launch any product under your brand. And if you don't get protection under all 45 classification, which means in class 12 you have a protection, but maybe in class 9 you don't have a protection, then it will be a problem, because your vendors, your suppliers can again trademark it, because they're not selling EV, they are selling EV components. If there is a charging stations, if they want to apply for a same name, they can also apply, because they are into class 37. Okay, so minimum classes that are required for your company is class 12, class 9 and class 37. Apart from that, if you get a well-known mark, well and good, otherwise you can skip that. So why trademark is important for your business? Because there is a rise in the companies in this particular domain and the number is continuously rising. As reported by the government in 2021 itself, there were 360 plus companies who are selling electric vehicles. How many are actually launching it in the market? That's a different question. But these many companies are registered to sell electric vehicles. With this increase in competition, your priority would be to establish your brand name, which is unique and which is liked by the customers. Trademark can be protected perpetually. One thing that you need to do is you have to renew it before the expiry of every 10 years. So by doing this, you can take this trademark from one generation to another generation. Next is copyrights. Copyright is a right given by the law to a creator of literary, dramatic, music and artistic works and producer of cinematographic films and sound recordings. Okay, a bundle of rights including rights of reproduction, communication to the public, adaptation and translation of the work. So most of the times people think that copyright is not important for their business, but there are few things that you can protect that may give you an upper edge during litigation matters. Okay, otherwise copyright can be skipped. People don't file copyright application, and also legally it is not mandatory. From the date of publication itself, you can say that you own a copyright provided you have your unique content. Okay, otherwise it will be difficult. But why to file? Because if you file a litigation suit against third party, the court should decide first who was the original creator. They will not trust you. They will investigate. If you are the original creator, then it will be enforced. Now, if you have a copyright certificate with you, prima facie injunction orders will be given in your favor till the case is decided. Means other party has to stop the activity that is infringing your copyright application. Earlier it was criminal suit, now it is a civil suit. Civil suit means you can recover the damage. Similarly with trademark as well, you can recover the damages. It's no more a criminal suit. You cannot file an FIR in your nearby police station. Now, from a business perspective, what can be a copyright? Okay, content of your website, the images of your product, the advertising content that you are creating, videos, sounds, whatever it is, that also is protected under copyright by default if it is unique. Okay, provided you are not buying the content from somewhere else. The most important thing for a business, electric vehicle business, is their engineering drawings. Okay, so whenever a product is manufactured, first you need engineering drawings on paper, right, or in a soft copy, whatever it is. Based on that engineering drawing itself, you are able to manufacture the product. So these engineering drawings, you can think of protecting it. By default, they have a protection, but getting a certificate for it. In case there is a duplication of your product, in that case you will get an upper edge. Okay, so there is one more act that you can add when you're filing a case when there is an identical product launched in the market. So one can be copyright, second can be counterfeit products. So you can think about getting a certificate of copyright for your engineering drawings at least. Okay, rest of the things you can directly mention copyright owned by you or your company. So normally the protection is for 60 years, sorry. Okay, or it is the lifetime of the author plus 60 years. Next is design registration. So anything that anyone is going to manufacture and sell, they will at least make sure that they are not duplicating the product. This is common sense, everyone has it. Okay, so if you think that design protection is important for you, the answer is yes. Why? Because it will add value to your company. If it is a startup, your valuation of the company will increase. So having a design registration for your company is must. So trademark is must, design registration is must. You have an option for copyright. Whenever you are manufacturing or selling a EV, okay, electric vehicle, first thing that you do is configure a new chassis. Okay, so you can have a separate design protection for the chassis. Then you have an unique aesthetics for your vehicle. Entire vehicle you can protect under design registration. So you may have unique consoles, unique tires, unique headlights. So you can split the components into multiple parts, which you think can be copied separately. Still, whatever small modification they are doing, still they are protecting under design registration. Even if you see the round headlights, there will be some differences when you compare it with different brands. Okay, think about protecting these also separately. One thing is valuation of your company will increase. Second thing is it will be easy for enforcement in case there is a duplication of single components. not the entire vehicle. Sometimes what may happen is, we will not create an entire vehicle. That headlights look good, that rear view mirror looks good. I will copy it, add it. I will make use of all 10 different manufacturers, one component. My vehicle will look different. Okay, so if that you want to stop, then my recommendation would be you should have protection for your entire vehicle and other components that you have created on your own, which are unique for your product. Okay, even small mountings, chassis, carriers that you are creating, cargo vehicles that you are creating. So most of the times people forget to protect these small components under design registration, because most of the times they don't have a vision to take this company to the next level. The people who are serious in this industry, those who want to continue their business perpetually, they may think of doing this, and they are doing it. Okay, if you see, the maximum number of patents that have been filed in this domain is by Honda. Okay, that includes design as well as patents. Okay, LG is also filing a lot of patents. So this is just to give you a glimpse of it. Okay, these are the few examples of design registration, how people are doing. So people are protecting their charging stations, their charging brackets, the entire EV. So many things have been protected. Okay, so almost 300-400 plus design registrations are filed in India as of now in EV domain. So the next important facet for EV is patents. Nowadays it is difficult to innovate in EV because it is much more crowded. Everyone with high-tech R&D capacity are doing this activity. So whenever you are launching a product in this domain, if you have done R&D, if you have improvised something, maybe it is with respect to storage capacity, maybe it is with respect to carrying capacity, maybe optimization of battery, maybe anything. If you think that you have invented something, okay, make a point that you protect it under patent. It is mostly crowded. In most of the cases, what manufacturers are doing, they are having an assembly line. Chassis and body they have, everything apart from that is imported or outsourced or bought from other vendors. Okay, it can be battery, it is bought from other vendors. They just make it a good shape that they want to adapt it. Okay, and they get it outsourced. There is no technology, it's a design, so you can protect this design battery under design registration if it is unique for your product. Okay, motors, there are efficient motors already been manufactured by other people. They are just adapting those motors for their vehicles, and they are creating a good assembly line and they are selling it. Okay, so if you have an assembly line in India and if you are importing products from outside, you may not need. So if you want to sustain in this business for a longer run, okay, for a longer run, in that case you can think about patenting in future. Okay, patenting is the most important facet of intellectual property. It's the most important. That gives you 100% monopoly in the market. If you have good and strong patents, okay, which will give you 100% monopoly in the market. If you have weaker patents, those may not be effective. It also depends upon your timeline of innovation. If you are innovating in real time and solving real time problems, maybe there are already people working on these problems, right? So for example, Tesla, they launched their vehicle very early into now. Without any marketing, they are selling their products. Now other manufacturers are trying to cope up with EV, and everyone is coming up with their own version of EV. But Tesla is way ahead of all the manufacturers. Okay, so you can plan something way ahead in time. In that case, if you have a vision of where the R&D can move or where the technology can move in coming future, in that case you should think about patenting it, because patenting is the only tool which will help you in creating monopoly. 100% monopoly means you just need to reach out to the clients and sell the product. That's it. Reaching out and selling out. Second best option is license it out to all the manufacturers. So for example, you have a good technology in battery. You made a marvelous battery which can give a mileage of 1000 kilometers. Just I'm giving you an example. May not be true, or maybe someone can come up with such kind of a battery. Okay, 1000 kilometers with a single charge. Okay, imagine. So to compete with your product, either they have to develop a battery, okay, or they have to license a battery from you. So most of the time people will approach you when they fail in R&D. First they will try it out on their own. When they fail, they will approach you, otherwise they will not approach you. So your target is to make sure that if there are possibilities, other possibilities by which you can create a battery which can use 1000 kilometers in single charge, in some other way the battery can be designed. So you make a point that you protect those kind of technology as well. May not be efficient, may not be 100% efficient like your batteries, but if they are reaching somewhere around 900 kilometers, 800 kilometers, which is a leap ahead of the existing technology, you may not be interested, but they will be launching this product in the market, right? So why not you do it to get the 100% monopoly? So when you are doing one invention which is very good and you are going to implement in your vehicles, think about how other people will get into market by doing some modification and achieve same results. So your task would be to put your R&D team on a task to develop all alternatives to solve this particular problem and make a point that you patent everything. So that will give you a advantage of 100% monopoly. And then if at all you don't opt for manufacturing the vehicles, you can choose that and just license out your patents to all the manufacturers and earn money. So with R&D capacity also you can do this. Think about it. Okay, so just to give you an example, Ericsson is out of market, but they had licensed their 4G technology, 4 essential patents on 4G technology to almost all mobile manufacturers. Okay, but they are not selling their own product. Now Nokia has around 5,500 patents on 5G. They filed a litigation suit against Oppo, OnePlus, and now Oppo and OnePlus are getting into an agreement with them because they cannot stop launching 5G products, right? They will get out of business. When they license a product, the price of product is going to rise. That is the upper hand that you can get. Okay, and additionally, without any litigation, Apple approached Nokia. What more beautiful can happen to a company, right? This is the strength of R&D and patenting. So R&D is also important and patenting is also important. If there is no option left for any other company to do something else to get the same results, then they will come to you. Trade secret. It's an intellectual property. For trade secret, there is no separate act in India, so you have to protect it by agreement. Non-disclosure agreements you have to make with your employees, your partners, your vendors, and everyone. With your vendors, you can also sign non-compete agreements. Okay. So trade secret is what? A trade secret is a practice or a process of a company that is generally not known outside of the company. Information considered as a trade secret gives the company an economical advantage over its competitors and is often a product of internal research and development. Okay, so most of the people think that trade secret is for the formulas or compositions, like Coca-Cola composition Coca-Cola composition, that can be a trade secret. KFC, how it is so crispy, that is a trade secret. What can I do for my business? What is a trade secret for me? Okay, so think about it. When you are manufacturing a product, your task is to reduce the cost. How you are going to reduce the cost? It requires lot of R&D and optimization, right? So that is your trade secret, how you have optimized your cost in spite of all hurdles, and still you are able to give good quality products in the market. Okay, this is what happened with Ola. They were not able to give best products for Indian conditions. So any formula, patterns, compilation of data, programs, devices if you are creating that you don't want to patent it, okay, methods, technique, any processes that you are adopting for manufacturing which are more effective and you don't want to protect it under patent, because once you file a patent, it will be in a public domain, everyone will know. At least after 20 years they can do it. So sometimes you may not opt for it. Okay, most important is your manufacturing processes. And the next is your customer list, your client list. Data is more expensive than gold. If I have a data of all potential EV buyers, wouldn't it be beautiful? I can camouflage my product, make it more attractive, at least on paper, and sell it. Whether it is good practically or not, that will be a different issue, right? But I can sell them a product, at least initially. I can get a leap ahead, and then maybe I will shut down my company as well. Okay, so whenever you are recruiting marketing team, or when someone is leaving from your team, it becomes a difficult task. Nowadays, switching the company has become a fashion. Okay, the most crucial resources of any company are their R&D resources, intellectual property resources, and their marketing resources. Okay, specifically, if you say marketing resources, they are hired for their experience in that particular domain, so that they can build their business easily. That's the easy cake that any company wants to walk through, right? That is the reason experienced marketing person from similar field is hired with 2x 3x salaries. Same is with the R&D. If you are doing good in a particular company, now do the same thing in my company, I will pay you 2x, right? So this is a problem. Maybe these employees may not have a future in may not have that great future, but in short term they are doing it, right? Similarly with IP, intellectual property, once the IP team knows how you are doing it, what kind of technology you are doing it, what is your strategy, and how you are able to do this all things very effectively and have a great market advantage using this intellectual property, it becomes very easy for that particular person to do the same activity in another company, right? So make sure that you sign non-disclosure, non-compete agreements with all your employees, vendors, and your partners, so that when they leave, at least they don't take away your intellectual property with them or your trade secret with them. So next important facets are other agreements that are required for your business. Specifically, if you are getting an investor, you need investor agreement. So in investors agreement, you need first entry and exit policy mentioned very clearly. Entry policy, exit policy. Because if there is no exit, once your company starts making money, they will not go. So make sure that exit policies are very clear. Entry policies, everyone makes it very clear. Entry is easy for everyone because they are giving money, they want to enter, and that is a risk that they're taking. Okay, inventor, if you are outsourcing the inventions to other people, if your team is inventing, make an assignment agreement with them. The inventors should assign this invention to your company. Otherwise, what may happen is they got an entire experience in your company, they know how everything is developed. Now they have one good idea in their mind, they left your company, they filed a patent and they started their own company. So make sure that if such something is happening, that you know that it is done in your company itself. You can claim that in future if you have this kind of agreements. Okay, so work for hire agreement, it is called work for hire because you are hiring them for R&D only. They cannot keep it to themselves, right? And if at all you can prove later on that this particular technology was developed based on the knowledge that you have given to them during their employment, their success will be little difficult. We have seen similar things happening. So once, I will just give you an example. There was one inventor who filed around 30 patents. I will not name him. He was working in a big bank, a software bank, okay? Software department of a bank. He filed all 30 patents in her name. Okay, he made minimum 50 lakhs investment when 30 patents have been filed. Okay, it was a very crucial technology for banking. And he approached us. We were not knowing, he never disclosed us what is the background. And he said that I want to license this patents, will you help us? We are willing to help. And we also had a client who was into this particular domain, the OEM, okay, who was patenting these kind of technologies through us. So we thought that it will be an easy money for us as well, because we already have a company who is into same domain. They may like it and they may buy it. So when we approached them, first they didn't respond with all 30 patents. They never said that we are not interested. When we approached them in person, the first question the patent head asked me was, where does the person work? From where did he got this knowledge? And it was never licensed. Till date, he is finding it difficult to license it out. So these are also the risks that are involved. So make sure that at least whenever you're starting a company, you're taking entire risk, and don't make a easy walk for other people who are working with you, who are partnering with you, or who are your vendors. Make them do something on their own and have their own success, but not on your knowledge. That is what you can do. So I hope this information is useful for you. And if at all you need any kind of support, we are there. I have given the contact details in the comment box. You can contact us if you need any kind of support. Next, one bonus I want to give you is I have given 2 links in the description box. Okay, so one is a landscape report of entire EV in India. So you will get the entire market scenario, what is happening with respect to EV in India. So you can download it free. And one more report is about global scenario of electric vehicles. So how many patents have been filed, who are the competitors, who have filed how many patents, which is the geographical area where maximum number of patents have been filed. So those all information you can get it through that document. That will make your life little easier. Okay, so I hope you like this video. So don't forget to share this video to the relevant person who are working into EV, or if they are doing anything that is related to EV, either entire vehicle they are making, or they are developing smaller some components for EV. Okay, so that they can understand how they can utilize this intellectual property effectively. And don't forget to like and subscribe to our channel. Okay, so keep inventing, keep investing properly so that you can earn tremendously in future. All the best for your future. Thank you.